So now, after this very fascinating, inspiring panel with these pertinent issues, we move on in our program. So after this short recess, we will now listen to a keynote. It's From Aggression to Accountability, Legal Pathways Toward Peace in Ukraine. And I'm pleased to introduce Anton Korynevych, Head of the Department of International Law and International Legal Counteraction to Aggression of Ministry of Foreign Affairs of Ukraine. This speech will address the role of international law in achieving a just peace for Ukraine, focusing on accountability for aggression, prosecution of international crimes, and legal mechanisms supporting sovereignty, security, and the international rules-based order. So I please welcome the floor to Anton Korynevych.
Yeah, friends, I would like just to add some words to representation of our good friend, great friend of Taras Shevchenko University, and actually a part of Taras Shevchenko University as it is associate professor of Department of International Law of Institute of International Relations, a great expert and great professional. Please, Anton.
Thank you so much, dear colleagues. It's a big pleasure and honor to be present today in my alma mater and university where I teach international law, where I studied it for more than a decade ago. And it's great that today we have this important international conference with the support of our Swedish partners and friends who are now leading on many tracks of support to Ukraine, including with military equipment, humanitarian assistance, and of course, assistance in our fight for just, comprehensive and lasting peace, of which, of course, accountability and justice are the indispensable parts. So today it is an honor for me to present a keynote address on the international law and how to achieve peace in Ukraine with regards to, of course, ensuring accountability and renewing justice, and also talking probably on the main and principal Ukraine's stance and positions in this respect. I recently presented quite a similar keynote in the German Mecca of international law in Max Planck Institute for Comparative and Public International Law in Heidelberg. So I really hope that today's address would be interesting and it would be important to hear this Ukraine's stance and position, both from government's official in the Ministry of Foreign Affairs, so from Ukrainian diplomat, and also from Ukrainian academic expert, and of course, the national of Ukraine, because I'm sure that all these messages and all the signals are important for all of us here in our Ukrainian cities. So first of all, I think it's important to start with a very basic notion that there can be no peace talks and no discussions over the peace for Ukraine without Ukraine. This is something very natural and very logical, but as we see in many international discussions and in many international forums and platforms, it is very important to start with this notion, so that whereas we all want this Russia's aggressive war to end, whereas we all want peace in our country, for our country, and whereas we all want just, comprehensive and lasting peace, no talks in this respect can take place without the direct participation of Ukraine. So this is something very important, and I'm sure that our friends in Sweden, of course, are in line with these ideas, but again, important to note. As a position or principle number two, for us as lawyers, it is of course important to underline that there can be no peace for Ukraine without justice. Justice is an inherent element of peace, and justice and accountability are absolute priorities for Ukraine on our pathway to peace. And this is something what we again underline during each and every international meeting, discussion, and conference, there can be no compromises on justice. Ukraine will not compromise justice. It means that whenever the peace will be achieved, we are sure that the ensuring accountability and justice must be the important element of this peace. In respect to this, it is also important to note that as of now, there are no points on compromises on justice and accountability which would exist in any peace plan or any draft agreement. This is very important to note because, of course, for many of you, you are aware that some time ago, some kind of a so-called 28-point plan appeared, which wasn't produced by Ukraine or with participation of Ukraine, but which appeared from some other sources. And one of these 28 points included the mentioning of amnesties or pardoning. So it is very important for us to mention today that as of now, this so-called 28-point plan no longer exists. As of now, we have 20 points plan, which is being deliberated, which is being discussed. And in this 20 points plan, there is not a single word on something which may be branded or called amnesty or pardoning. And we, the government of Ukraine, will be doing the best of our abilities not to let any idea on amnesties or pardoning to reappear on any kind of deliberations and any kind of document or plan or whatever we call it in relation to reaching peace for Ukraine. In this respect, of course, it is important to mention that a lot of international partners of Ukraine support continuation of the work on accountability and justice, including European Union, Council of Europe, and of course, Sweden. So it would be illogical and unnatural to stop the work on accountability and justice, looking back at all the interim provisional results and outcomes which we have achieved starting from late February 2022, of which we will be also talking today. A lot of things have been done and a lot of important results have been achieved, and thus this work must continue. When we talk about the peace in Ukraine and for Ukraine, we are talking about a peace which should enclose three important elements. So first, the peace should be just. It means that it should be fair in relation to Ukraine and Ukrainians, and it means that it should be just in relation to the basis of this peace on justice and accountability. This peace should also be lasting. It means that whatever and whenever the peace is achieved, it should last. It should make impossible for the war to renew in some years, as we actually saw when the aggression started in 2014, and then another stage of the aggression of Russia against Ukraine appeared in 2022, the full-scale invasion. So lasting, meaning that we hope that when the peace is achieved, it will last and the war will not reappear. And peace must be comprehensive, meaning that the peace and the peace agreements, which hopefully will lead to peace, will include all the important elements which are necessary and indispensable, inherent for this peace to happen and for this peace to be just and lasting. And in relation to this, of course, since justice and accountability are indispensable elements of peace for Ukraine, it is important, I think, to underline what is Ukraine's vision of justice in relation to Russia's aggression and in relation to reaching peace. So what is this justice about? What are the elements of this justice? how does Ukraine see this justice? So first of all, for us, for Ukraine, justice is use of all the existing international instruments and tools which are available for us to go for Russia's accountability for the violations of international law. So the first part is we, Ukraine, use each and every possible international mechanism, instrument and tool to bring Russia to account. And we very actively do this since the very start of the Russia's aggression in 2014. Namely, we use such mechanisms and tools as the International Court of Justice, where we have interstate cases of Ukraine versus the Russian Federation. We actively use the International Criminal Court, which now investigates the situation in Ukraine in the frame of the case situation in Ukraine, and has already issued 6 arrest warrants for Russian nationals, including for Vladimir Putin, for allegedly committing war crimes and crimes against humanity. And it is a big pleasure for Ukrainian international lawyers that Ukraine became the member of the Rome Statute family since the 1st January 2025. So it is important, and I think it's important to mention and not to be very modest, that for a state to become a state party to the Rome Statute, when the hostilities are very active, this is really something I believe remarkable. We also use the instruments of law of the sea tribunals, and we have several cases against the Russian Federation in the arbitral tribunals established under Annex 7 to the United Nations Convention on the Law of the Sea. And these cases are administered by the Permanent Court of Arbitration in The Hague. And of course, when we talk about the existing international law instruments and tools, we of course mention the European Court of Human Rights, the principal judicial body of the Council of Europe, which, as we see now, is very strongly working in order to get accountability of the Russian Federation. Several decisions, judgments already proclaimed by the ECHR, in particular the judgment in the Crimean case and the judgment in the case Ukraine and the Netherlands versus the Russian Federation in relation to the downing of MH17 flight. And these 2 cases, we may claim it, are absolute and total victories for Ukraine. And we hope and we are sure that the other cases in Strasbourg will also be such victories, and European Court of Human Rights will underline in these judgments massive and systematic and widespread violations of the European Convention on Human Rights by the Russian Federation. And in addition to this first element of Ukraine's vision on justice, use of all the existing tools and mechanisms, we also have the second element, which is on the work on the new Ukraine-related accountability instruments. We, of course, all understand that international law is quite a conservative system of law, which is not very suitable for working efficiently and speedily in relation to establishment of new institutions. But for us, for Ukraine, it is also obvious that Russia's aggression against Ukraine showed us that there are some glaring gaps, glaring loopholes in the system of accountability for the Russia's aggression against Ukraine, which we must close. Because if we do not close these glaring gaps and loopholes, we will not be able to say that we, together with our partners, did everything possible for justice and accountability to take place. We consider that we have at least 2 of such glaring gaps and loopholes which we, together with our international partners, must close. The first one is the absence international compensation and reparation mechanism for Ukraine. Russia's brutal war of aggression brought many damages to both Ukraine as a state and to Ukrainian nationals, both in relation to personal losses, in relation to loss of property, and many other spheres. Unfortunately, as of now, we do not have the fully fledged international compensation mechanism which could address these damages and which could make decisions on reparations or compensations to be made to Ukraine as a state and to Ukrainian national, to Ukrainian legal entities, businesses. So that is why, in the absence of such a mechanism and having this glaring gap, Ukraine came out in 2022 with an idea and a concept to establish the international compensation mechanism, which must close this gap. And this international compensation mechanism shall be composed of three elements. The first one is a register of damage, which currently operates in The Hague and in Kyiv, which is administering and registering claims from Ukrainian national businesses and state in relation to the damages and losses which appeared during Russia's war of aggression and which were caused by the Russia's war of aggression. So it is very important that the first element of this fully fledged international compensation mechanism is already in place and actively works, register of damage. And this is something what we all know. And again, we are grateful to all our international partners who assist us and who support this endeavor. The second element of the international compensation mechanism should be the International Claims Commission for Ukraine, which should be not a judicial, but an administrative body, which will take all the data, all the claims from the register of damage, and which will make decisions on these claims, who gets what. So the job of the Claims Commission would be to actually make decisions on concrete amounts of compensations, reparations, which are to be paid to those who made these claims. And it is very important that the work on the establishment of the International Claims Commission really now goes in a good speed, with a good tempo. The convention on the establishment of the Claims Commission was signed on the 16th of December 2025 in The Hague. As of now, several states have already ratified the convention, as Ukraine has already done. Just yesterday in Brussels, Canada became the first non-European state who signed the convention. And we hope that several other states will sign the convention this week during the ministerial conference, ministerial meeting of the Committee of Ministers of the Council of Europe in Chisinau, which will take place on Thursday and Friday. It is really important that we get, as soon as possible, 25 ratification of this convention, because after 25 ratifications, the convention will enter into force and the Commission will start its operations. So this is something what, again, we can do together. And of course, Ukraine will be happy to see Sweden's ratification of the convention. It will be an important sign and element of support of this endeavor. And the third element of the fully fledged international compensation mechanism, compensation fund. Whereas the register of damage just registers the claims, then whereas the Claims Commission makes decisions on these claims, the compensation fund is to reimburse for these claims, is to pay for these claims, to give concrete amounts to persons who suffered these losses. And of course, the establishment of the third element of the compensation fund is of utmost importance, because without it, the full system will be null and void. Now, the discussions on the establishment of the compensation fund are very active, because when we started the work on the establishment of all the three elements of the international compensation mechanism, the decision together with our international partners was made to have a step-by-step approach, to establish the register of damage, to see it's operational, then start to work on the establishment of the Claims Commission. We now have the Convention on the Claims Commission. Now we moved to the establishment of the compensation fund. And of course, it is very important to underline that in Ukraine's view, this compensation fund must be filled with Russian assets. So the compensations must be paid from Russian assets, in particular sovereign assets, which are now freezed in some jurisdictions, in particular in Europe. We believe that if the compensations are paid from other sources, not from Russia's sovereign assets, this will not be compensation per se. It may be claimed or called financial assistance, financial support, but it will not be compensations, because compensations must be paid from those who was the source of the loss and damage. And we believe that the legal formula for the use of the Russian sovereign assets for the sake of compensation fund can be found. We believe that the international legal theory of countermeasures, which is a classical one in international law, which is enshrined in articles on state responsibility for internationally wrongful acts, which is not new to those who work with international law. We believe that this concept, theory, and doctrine of countermeasures can be the basis for moving forward with taking Russian sovereign assets for the sake of compensations and reparations to Ukraine and Ukrainians. So we are sure that this decision can be found. And there is a second glaring gap, second glaring loophole in the system of accountability for Ukraine. And for us, this gap is, I wouldn't call it the most important one or the primary one, but without it, the whole system will not suffice and will not look as a structured system as a whole. This is, of course, the lack of mechanism which would ensure accountability for the crime of aggression against Ukraine. The crime of aggression, which is the mother of all the international crimes, which is a primary international crime, which in our Ukraine's case is a root cause to all the other international crimes which were committed on the territory of Ukraine. Just try to imagine, before 2014, we in Ukraine had not a single war crime committed on our soil. Not a single crime against humanity committed on our soil. Our law enforcement, our prosecutors' offices, our courts, our judges just didn't know even how to work with these categories of crimes because, of course, they are very special ones, because we had no practice in real life of it. And after the Russian aggression started in 2014, we now have more than 200,000 of war crimes registered only within Ukraine's prosecutorial system. This is the biggest number of crimes ever registered in the world, I believe, throughout all the armed conflicts. And of course, Europe hasn't seen this since the Second World War for sure. So we believe that having this situation, it is really important to tackle and to ensure accountability, not only for the crimes which actually are the result of the crime of aggression, which are, of course, war crimes, crimes against humanity, and genocide. But it is also important to tackle the crime of aggression itself and to ensure accountability for the crime of aggression against Ukraine itself. Because if it wasn't a crime of aggression, we wouldn't have seen everything else. Moreover, we also feel that for historical truth and for the justice in the historical concept approach, it is really inherent to establish accountability for the crime of aggression against Ukraine, because Russia's aggression against our nation is the biggest aggression in Europe, at least in Europe, after the Second World War, if not in the whole world. So if this crime of aggression is left without response, there is a question may be made whether the concept of the crime of aggression at all exists in international law, whether the principle of non-use of force or non-threat of force exists in international law and really makes some difference for states today. So I think for the whole international rules-based order, it is important to ensure accountability for the crime of aggression. And that is why Ukraine actively works with our many international partners, like Sweden, of course, since late February 2022, to get accountability for this crime of aggression. We have proposed, and our partners have supported, the establishment of the special tribunal for the crime of aggression against Ukraine. The special court, which would be a complementary to the International Criminal Court, but which would have jurisdiction over one crime over which ICC cannot exercise jurisdiction in relation to the situation in Ukraine, the crime of aggression. So the special tribunal as a unique ad hoc international court, which would deal with only one crime of aggression, only in relation to the Russia's aggression against Ukraine. And it is really important to see how this very concept emerged back then in late February 2022, and how it developed in these 4 years to the situation which we have right now. We have established, drafted the basic documents for the establishment of the special tribunal, namely the agreement between Ukraine and the Council of Europe on the establishment of the special tribunal, which was signed pretty much a year ago on the 25th of June 2025 in Strasbourg. We have also drafted the statute of the special tribunal, which is also now signed as an inherent, indispensable part of the agreement between Ukraine and the Council of Europe. Ukraine has already very quickly, in 2 months, in July 2025, ratified the agreement and the statute. And this whole is a product of the work of the core group of states, an informal gathering of legal advisors from ministries of foreign affairs from 40 states and several international organizations, which gathered starting from January 2023 till March 2025 for 14 times in different places throughout Europe to draft the legal basis, the legal architecture for the special tribunal. And the third element for the establishment of the special tribunal, which is currently being very actively in work, the enlarged partial agreement on the management committee of the special tribunal. The agreement, which will not be only between Ukraine and the Council of Europe, but to which other states will adhere, will accede, and which will establish the management committee of the special tribunal, something like an assembly of states parties, which would make all the most important decisions on the functioning of the special tribunal, on financing budgetary issues, on security issues, on administrative issues, election of judges, prosecutor, etc. So it is really important that we have this EPA as soon as possible. And it is really important that this Friday in Chisinau, during the ministerial meeting of the Committee of Ministers of the Council of Europe, this enlarged partial agreement will be adopted. And this should be the most important highlight of the Chisinau ministerial of the Council of Europe. As of now, almost 30 states have notified their intention to join the enlarged partial agreement and to establish the management committee of the special tribunal, to be part of this process, to be part of the management committee. Whereas the needed minimorum for the enlarged partial agreement to be adopted is 16. So as of now, it's already twice as more. And we have still several days till Friday, so we hope to get more such notifications because, of course, each notification strengthens the whole story, strengthens the tribunal, the enlarged partial agreement, and the management committee. It is very important, and we are grateful that Sweden was among the first ones who notified the intention to join the EPA, and we hope that Sweden, together with us, will celebrate this Friday this important moment, this important momentum on the way to establishment of the special tribunal. But it is very important to mention that Friday in Chisinau is not the end of the journey. This is important momentum, but the journey will continue. After this, states will need to take internal procedures in order to be legally part of the enlarged partial agreement. Some states, like Ukraine, will need to have parliamentary process. In Ukraine, it will be accession, the law of Ukraine on accession to the enlarged partial agreement, which is quite the same as ratification. For some states, for instance, for the Republic of Poland, they will need government's approval as a resolution of the government. So each state has its own rules and procedures. But after Friday, it will be very important that we collect these internal ratifications or approvals as soon as possible, because then it will enable us to start the work of the management committee. So again, I believe that for both Ukraine and Sweden, there will be some work after Friday to conclude internal procedures as soon as possible. In relation to the topic of regaining peace, I think there are several other signals and messages which are important today to talk about, not losing a lot of time for this. I think it is obvious, but still important to mention that whenever we are talking about the end of this Russia's war of aggression, its finalization shall take place in the form of a treaty, which must be legally binding and shall include concrete obligations for the parties. We all know how Russia treats international law, its international obligations. We all know about the so-called Russian approach to international law, but still we believe that wherever we are coming closer to peace, this war should not end with some kind of a declaration or memorandum. This war should end with a treaty which will be legally binding and which shall include concrete obligations for the parties. It is also very important to have strong security guarantees from our international partners. It is a very important element of the whole peace infrastructure, because whenever Russia sees concrete and strong security guarantees from our international partners, it will think twice or even three times whether it will need to renew the aggression in several years, as it has already done. Without strong guarantees from international partners, we believe that Russia might reconvene its hostilities. So it is really the very important element. Also, after this war ends, Ukraine must remain strong to be able to combat any possible future Russian aggression. This means, of course, strong Ukraine's armed forces and other elements of security and defense forces of Ukraine. We will need support from our partners and friends, in particular from European ones, in order to keep our Ukraine's armed forces prepared for any kind of renewing aggression. And again, this is an indispensable element because we all understand here in Kyiv that if it wasn't Ukrainian army, we wouldn't sit here. And this is a very, very true story for everybody. So I think that both for Ukraine and both for our international partners, it is really important to keep supporting Ukraine's army after this war ends. And there is one more issue which now appears highly on international media because of Russia's comments, because of Russia's position and Russia's ideas. And again, we feel that today it is very important to mention that there must be and there will not be no concessions or compromises on Ukraine's territories within any kind of peace talks, within any kind of documents, including those territories which are currently controlled by Ukraine's government and Ukrainian armed forces. Nobody will do this, no matter what Russia wants, no matter what Russia shouts in international media, because this is something what is indispensable for contemporary international law. No state abandons its land and abandons its nationals who reside on these territories. And this will not be done in this case. So it is really important that we, together with our international partners, whenever we will be closer to reaching peace agreement, this idea must not be deliberated and must not be supported by our partners and friends. With this, I think I will end my keynote remarks. We really tried to make it full in having the picture of international law as an inherent element of just and lasting and comprehensive peace for Ukraine. And this is again to reassure you, dear colleagues and friends, that for Ukraine, there is nothing more important and precious than peace. And this is something which I'm sure we don't need to tell you even. But this peace should be real peace, should not be just concessions to the one who can renew its aggression whenever somebody sitting in Kremlin will make such a decision. Thank you.
Thank you very much. Yeah, please, Victor. We've got for about 5 minutes, probably for some questions. I suggest our Swedish colleagues shall be first. Dear friends, do you have any questions to Mr. Korynevych? Yes, please. I can see the hand.
Thank you. I have a question about statutes of limitation. Have all statutes of limitations for war-related crimes been removed in Ukrainian legislations? Or are there still such limitations left?
Thank you very much for your question. Well, I think the most important thing is that there are no statutory limitations for international crimes in Ukraine's criminal code. So whenever we talk about war crimes, genocide, or crime against humanity or aggression, we now finally have all these 4 categories of core international crimes, with recently adding crimes against humanity. Statutory limitations will not apply. And the same goes in relation to the ICC. Yes, so ICC also is not limited with statutory limitations. In relation to more vaster category, war-related crimes, meaning, some ordinary crimes committed, let's say, on temporarily occupied territories or on territories which are close to the hostility zone. Well, there still are statutory limitations, but they are there because they are considered as ordinary crimes. But whenever we talk about core international crimes, this shall not apply. Thank you.
Thank you very much. So, colleagues, we have any question, please?
I was wondering if you could expand. You said that there has to be a treaty, not just a memorandum, or for someone who's not a lawyer, and given that Russia has a history of not acknowledging any or living by any document,
Thank you.
the point of a treaty?
Quite a natural question, a logical one. Well, I think it's obvious that nobody believes Russia at all. But we hope that this international armed conflict will come to an end. And that if we have a treaty which is based on international law, which hopefully has some oversight mechanism, including from international partners, then it will be better than having just one-pager declaration with no obligations, with no commitments. So, when we talk about Russia, I'm sure we cannot be sure of anything at all, but I think that this is better guarantee that having something which is not legally binding.
Okay.
Okay. Thank you very much. And probably the very last question from Sweden, if you've got one. Dear colleagues from Sweden, any question for us to be in timing?
No more questions from Sweden.
No more questions. Okay. Last question. So huge thanks, Mr. Korynevych, dear Anton, and all of us who is waiting for this Friday and for the further results, positive results. And we all believe in our victory. Thanks a lot.
Thank you.